The next matter is U.S. Bank versus Rothmel. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I want to thank both counsel for coming in to do this virtually. This allows us to fulfill our constitutional obligations to do justice in a fair and timely manner. So I appreciate your cooperation. Is the appellant ready to proceed?
Chief, before you begin, you are, at least for me, coming in and out of the feed. I don't know if that's true for other members of the court.
Thank you, Justice McDonald. Let me try something. I'm having some bandwidth issues here. I apologize. If it gets too bad, then what I'll do is I'll drop out and watch the proceeding and go from there. Because I am having bandwidth issues. I'm going to.
We can hear you, Chief. It's just you sound a little like Darth Vader, but we can definitely hear you and we can see you. So I don't know if that affects your decision.
Okay, well, I'll try to go with it. If I'm still getting a notice though that I'm having poor network quality issues here, so we'll just try to make do. Thank you very much. Are you ready to proceed, counsel?
I am, Your Honor. My name is Christopher Brown. I represent the appellant, Carol Rothmel. I'm admitted to practice before this court, and I would like to reserve 7 minutes for rebuttal.
Thank you. And today, Justice Dario will be our timekeeper. He will let you know when there's 5 minutes remaining in your argument. So if you'll please, thank you, Justice Dario. Counsel, I just need you to make sure that you watch the screen. If you see a justice's hand come up, then please stop talking. I'll acknowledge the justice and they'll ask the question. Thank you very much. Whenever you're ready.
Thank you, Your Honor. So this morning I would like to address 1 point on the mootness issue and 2 points on the decision on the motion to open. The point on the mootness issue is that this court in Jager told us that there is no bright line test for, or I should say, the law date is not a bright line test for determining whether a motion to open a judgment can be granted after the law date. And the reason for that, this court told us, is that a foreclosure proceeding is equitable, and the legislature was aware of that when it passed Section 4915. And equity does not allow itself to be confined to a bright line test for determination. Depends on the facts and circumstances of the case that's before the court. And at page 261 of the opinion, the court said, consistently with its authority to exercise its equitable discretion in foreclosure proceedings, the trial court must be afforded the authority to open judgments on a case-by-case basis in order that complete justice may be done. So since the law date is not a bright line test for determining whether the judgment can be opened after the law date, it's not a bright line test for determining whether the court can grant relief after the law date. And since it's not a bright line test for determining whether the court can grant relief after the law date, it's not a bright line test for determining mootness. So for that reason, it seems that the appellate court's decision to dismiss the case for mootness was improper. Turning to the decision on the motion to open, the trial court found, yes, Judge?
If I may, Chief.
Just a second.
Thank you. A couple questions on the mootness issue. These may be better asked of your opposing counsel, but this will give her a little chance to prepare. And I would like your input on it as well. Malon and Jager. Jager, did the trial court in that case open the judgment, or was it a reversal? Did the trial court decline to open, and then this court said no, you can?
You know, Judge, I don't recall. I do know that this court reversed. I believe it was the appellate court. I guess had reversed the trial court. I'm not sure. Can't really answer the question.
Okay. Well, I know in Malon that the trial court declined to open the judgment, and then the appellate court reversed. And I guess my question is, if the appellate court in this case is right, in the present case is right, that there's no jurisdiction, why would the appellate court have had jurisdiction in Malon? And it's a rhetorical question, I suppose. I mean, unless you have an answer, and maybe it's better for your opponent. But it seems to me that your claim here is that the trial court has refused to exercise authority under 4915 and found that that's not appropriate, and it's not going to do it. It doesn't have jurisdiction to do it. It shouldn't do it as a matter of discretion. It's not doing it. And you're looking to appeal that decision, right?
Yes, Judge.
And if you win your appeal, then there's a reversal, and presumably you can get some relief, right? I mean, yes. you only can't get relief if you lose your appeal, right?
Correct.
Okay. And is that your mootness point, that it's not moot because if you win, you'll get your relief?
Yes.
Okay. I just wanted to clarify that. Thank you.
Very well. So return.
There's a question, counsel. There's a question from Justice Mullins.
Oh, sorry.
Justice Connor, I think you were before me if you want to go.
I believe I raised right at the same time as you. I will defer to you as more
Okay.
senior. I didn't check, sorry, as closely,
Nope.
but I'll wait. If it's
No
okay
problem.
with the chief, I'll wait.
That's fine. Just a quick clarifying question. So on the mootness point. So this was a motion to open, right? We're not talking about the underlying foreclosure. The relief you would be seeking would be to have the motion to open heard.
Yes, actually granted.
Motion to open granted. Well, you'd have to demonstrate, right, that it should be granted, right?
Yes, as I understood the two certified questions, the first one is, is the appeal moot? And the second one is, if it's not moot, did the trial court properly deny the motion to open?
And in terms of the court exercising its authority or not, why isn't it a bright line test absent some equitable reason to open? So if there's no fraud or sort of some other equitable reason to open after passage of the law day and the title vest in someone else, why isn't it a bright line test to the extent that there's no other equitable problem?
Well, because to me, Your Honor, bright line test means the judgment can never be opened after the law date. So the motion would have been moot then in the trial court, but
well, many judgments can be open. I mean, if the judgment was procured by fraud, I think that is a circumstance where you may not otherwise be able to open a judgment, but you would open it because that's a fraud on the court. You can't allow that to go forward. So I'm just wondering if there's no equitable problem, why wouldn't the bright line be what it says in the statute?
I guess maybe that I would take what you said, Your Honor, and maybe rephrase it a little bit, in that if the basis of the motion to open is an equitable reason, then you don't have the bright line of the law date barring the motion. And so the motion to open in this case did assert an equitable reason.
Was there a hearing on that? I mean, because you could assert an equitable reason, but then after the court reviews it and determines that, it's not really valid, then you're back to there's no equitable reason to go another way.
Well, the way that I would understand the court's decision in Jager is you have to weigh the equities and make a determination about whether, in this case, the equities weigh in favor of opening the judgment. So that weighing process is something that the trial court did do, conducted an evidentiary hearing, and weighed and made determinations about what the equities were. And so if the appeal is going to be dismissed as moot, then that trial court decision is being insulated from appellate review. It was a weighing. It happened. That's what the trial court did.
Thank you.
Justice Khan.
Thank you, Chief Justice Robinson. Counsel, I have a couple of questions, and they're related to, I believe, the issues Justice Mullins raised with you. Somewhere in the record, I read that that maybe your client had some equity in the property, but it doesn't look like your client did because this is a strict foreclosure. It wasn't a foreclosure by sale. So my question is there any claim that your client has some equity in the property?
Not as of the date that the judgment was rendered. I don't know what may have transpired since then in terms of property value, but no, there's no claim that, based on the judgments that were entered, she had any equity in the property.
Okay. So at the time foreclosure, a strict foreclosure was issued, there was no equity. Okay, so then my next question is, the court seems to, the trial court seems to, in its decision, start off by saying, look, you could open judgment if one of the exceptions under 4915A applies, but neither one of the two exceptions apply. But then the court goes on to kind of consider your client's argument as to why she missed the law day. And her claim was, even though she received notice, she somehow thought through communications with counsel that it was a day later. And I'm looking at A171 of your appendix in the trial court decision. Moreover, it is difficult for this court to find that the defendant who has successfully been able to open judgments of strict foreclosure and extend the law days up to 16 times would be unaware of the difference between a strict foreclosure and a foreclosure by sale, and between a law day and a sale day. So, and I know the issue is whether the court should have opened judgment or not. But now getting to the merits of what the court did, how did the trial court get it wrong? What is your claim?
Well, there's 2 points there. One is ROTHERMEL didn't open the judgment 16 times. 14 of those motions were plaintiff's motions. She filed 2. One of them was never ruled on, and the other one was denied. Although I think the court the court extended the law date anyway, even though it denied the motion. The second point is, her claim is not that she misread the servicer's February 20th, 2019 letter as telling her that her law day was March 13th. Her claim is that the servicer's February 20th, 2019 letter was misleading in that it makes representations about what was going to happen after the law day that were entirely consistent with rights that the bank could have exercised after the law day. The letter is at 208 of the record. And the first sentence is, mortgage servicer on the above reference account is notifying you that the previously scheduled foreclosure sale of the above noted property has been postponed and rescheduled to occur on 3/13/2019. Well, the court didn't schedule any foreclosure sale, and the court didn't schedule anything to happen on 3/13/2019. In fact, 3/13/2019 is the day after the law date, is the day that the bank owned the property. And if the bank owned the property on 3/13, it could have sold the property on 3/13. So the first sentence of this letter seems to be telling Rothermel, we scheduled the sale of your property for the day after the law date when we take title. The second paragraph then goes on to talk about, I'm going to paraphrase here, if you have an open application for a foreclosure alternative that's complete, we will postpone that March 13th sale. So she had a complete application for a short payoff. And there's nothing in that paragraph that would suggest to her that property is now, we're going to put the property out of our control and beyond our reach on the 13th, but we're not going to do that if there's an open application for a foreclosure prevention alternative that hasn't been decided.
Well, let me just ask a quick follow-up question. Help me out with the timing here. This letter is dated February 20th, 2019, and the notice of the law day went out when?
I don't know, but certainly the order granting it, granting the extension to March 12th was the day before, February 19th.
Okay. And so your client doesn't seek clarification of that? She gets a law day on February 19th from the court, and then a letter dated February 20th and doesn't seek clarification of that?
Well, her testimony was that after she received the letter, the February 20th letter, she had some 25 conversations with the servicer. The record doesn't about, her testimony was that the context of those calls was servicer saying, we don't want to foreclose on you and your short payoff application may be revisited. What we do know is that there's nothing in the record that suggests that the servicer ever corrected any of the information in that first sentence about the March 13th date. In fact, on the evening of March 12th, the evening of the law date, she had a telephone call. She calls the servicer and says, my law date's today, what's going on? And the servicer responds, your foreclosure sale is tomorrow. So as late as the evening of March 12th, the servicer is telling her that the D-Day is the next day.
Let me, okay, I understand your response. I don't mean to cut you off, but I recognize my colleagues have their hands up and I don't want to take up all of the time. So if you want to finish the response to me, that's fine, but I would defer back to the Chief Justice so I don't want to monopolize all the time of the argument. Thank you, counsel.
Sure. Thank you, Justice Khan.
Counsel, did you finish answering Justice Khan's question?
Oh, the only thing that I was going to add is something happened. There was a second conversation on the night of March 12th with the servicer, and something very different happened after that conversation.
Thank you, counsel. I believe the order is Justice McDonald first, then Justice Doria.
Counsel, I'm just trying to conceptually understand the argument. Well, first of all, let me pose a hypothetical. If the foreclosure was completed and title had vested, and in a hot real estate market, the bank had sold the property to a third party, would that party not have title if you were correct? Would they be dispossessed of the property?
Well, no, I think the purchaser would not be dispossessed, but that would be a equity that would be put in the scale that would militate against opening the judgment after the law day.
So, and let me ask maybe a different way. If there had been, I don't know the details enough of this case, if there had been 5 subsequent encumbrances, and your client had actually redeemed on the law, her law day, right? You would have assumed that the it goes in the inverse order of priority, right? So you would have assumed that it was free and clear of any subsequent encumbrancer, right? I mean, there's got to be some finality to a law day, doesn't there?
There does, Judd. There does. But here, there weren't any subsequent encumbrances. And since the determination is made on a case-by-case basis, we have a circumstance where the property at the time that she made the motion had not been put beyond the court's reach. It was still in control of the plaintiff in the case because it hadn't been sold.
And I understand your advocacy for your client in this case, but conceptually, at the conclusion of a law day, the property interest that existed on that day is extinguished completely, right? I mean, if there was a second mortgage or a lien, a mechanic's lien, at the end of that day, it's gone completely. It cannot be revived. So what do we do with that in this case with your client? I mean, you might have a claim for misrepresentation against the plaintiff or something else, but isn't there finality at the end of that law day?
Well, I cited in my brief that there is a statute that would allow the court to restore title, right? Court can, in exercising its equitable discretion, can basically rearrange title. That's one thing. The second thing is the provision in 4915A2 essentially allows the court to restore the parties to the status quo existing before the law date. So it's not. I don't know that the law supports the notion that the vesting of title is absolute, that it can't be changed by an order of the court. And as a practical matter, Your Honor, in this case, there would be nothing stopping the bank from reconveying the property to Rothermel if it decided to accept her short payoff application. It could have just given her a deed. And if they had agreed after the transfer, 4915A2 would have permitted them to consent to restore the property to the status quo before the law date. So there's not a, I guess what I'm saying is the absolute vesting is not necessarily absolute in all cases.
I hear you. It's going to be interesting to see how this plays out, because at the end of that law day, the note and mortgage merge and are extinguished. So there's an argument to be made that the plaintiff no longer has a mortgage that can be enforced. It was extinguished and merged with title. It's kind of like a miraculous, legal fiction that it just all of a sudden merges and it's gone, and all they have is the possessory interest in the property with title.
Yes, I get that appearance. I would just go back to 4915A2, which seems to contemplate that can be undone.
Thank you.
Chief, I'll go if that's okay. And counsel, I'll give you your 1 minute warning as I ask this question. I'll try to ask it concisely. You don't hide from this. You've got it in your brief, but in addition to the finding that Justice Kahn, asked you about, the court says at the end in its conclusion that it doesn't find that the defendant was confused by the letter. So I assume that you put your client on at this hearing, and Judge Gennario made some findings, didn't credit, either because he felt, people protect themselves. She has an attorney. I mean, so you've got a very narrow exception with a clearly erroneous factual finding you've got to get over on an abuse of discretion standard on motions to open. Where does that leave us? I mean, what can, without blowing a hole in sort of law days?
So, Your Honor, I have said that I think Judge Gennario misconstrued the issue when he said that he couldn't find that she was confused, because the issue isn't, she wasn't claiming, right? If the conclusion is that she knew the law date, she knew there was a law date, she knew it was a strict foreclosure, and she knew that date was March 12th, then the letter's not confusing. The issue is they told her something was happening after the law date, after they got title. There's nothing about that letter that suggests that anything in that first paragraph there is inconsistent with the law. They would have owned the property on the 13th, and they could have sold it on the 13th. And in fact, that first paragraph can't be alluding to a law date that's happening on March 12th. It can't be a mistake about that, because, may I finish, Your Honor?
Yes, Counsel.
Because the court didn't order a foreclosure sale, it ordered a strict. So this letter has to be telling her something different. Thank you.
Thank you, Counsel. Counsel, you ready to proceed? You're muted, Counsel. Your microphone is muted. Still muted.
I apologize.
No problem.
Your Honors, Geraldine Chaverko of Eckerd Siemens for the plaintiff in this matter. The answer, the certified question as framed by this court is if the appellate court properly dismissed the appeal as moot based on alleged misrepresentations by the plaintiff. The answer to this question is clearly no. Despite the bilateral confusion, and that's the way that the defendant framed it in her brief, this purported confusion was by the parties, not by counsel. And Ms. Rothermel was represented by counsel for, I believe, 5 years. Her counsel was still representing her when the law day yes, Your Honor.
Justice Eckerd, Justice McDonald, is your hand up?
I didn't see that. Justice McDonald, do you have a question?
Justice Eckerd.
Okay. Thank you, counsel. I'm just stopping you quickly because you, from what I hear anyway, you've moved from the jurisdictional question, that is the mootness question, to the merits, and I want to stop you and dwell a bit on the first question, if you will. As I understand it, your argument, even to our court on point 2, is not that Meilon was wrongly decided, but rather that this defendant doesn't meet the equitable requirements and made no showing that would warrant reopening under 4915. That's the substance of your argument? The
substance of my argument is, yes, the trial court, there was no agreement pursuant to statute, and then the trial court analyzed it under Milan, and she never claimed fraud.
So my question for you is, why doesn't the appellate court have jurisdiction to decide whether or not you're right? Or that, just to put it in favor of the appellant, I guess, that the defendant is right and that Judge Gennario got it wrong on the merits. Why doesn't the appellate court have jurisdiction to decide that?
Your Honor, when this was submitted to the court, it was submitted as a motion to dismiss the appeal. That was granted on default. And then there was a motion for reconsideration. The appellate court had all of the documents that were in front of the lower court when it made its decision that the appeal was moot.
Right, but I'm asking you, why was the appeal moot? I mean, why are you right? Let me put it a different. Let me ask you a different question, and you can answer it any way you want. I should let you do that. But if you were right about your reasoning in your motion to dismiss, if you're correct, then why did the appellate court in Milan have jurisdiction?
The appeal was moot here because the court could not grant practical relief. It didn't fall, the facts did not fall under the statutory 4915A2, and it also did not fall under any fraud, any basis of fraud.
Well, it couldn't grant practical relief if it was right. I mean, if the trial court was right, then it couldn't grant practical relief. But what if it was wrong? As in Milan, the trial court denied the motion under 4915. And then the appellate court said, no, I believe this is true, by the way. I haven't read it in a long time. This is from memory. But it said, no, that's an incorrect holding. There was fraud here. There was that misconduct and all that kind of stuff, equitable misconduct. And 4915 does not prevent the trial court from reopening. So why did the appellate court have jurisdiction in Milan but not here to take up the merits of the question of whether the trial court was right or not?
Well, the appeal is moot, as I said before, if no practical relief can be granted. If an appellate court can always reverse the lower court or the trial court's decision, then what does that rule stand for? Because an appeal would never be mooted.
Well, let me give you an example. Let's say, for example, that there had been no appellate stay here, and the house had been transferred or conveyed, or maybe something else happened. The bank decided to agree to modify. That would moot the appeal. I mean, there are ways in which the appeal could be mooted, and I'll stop there because I've taken up enough of your time. It's just odd to have a rule that says that if the trial court is correct, then the appeal is moot. But if the trial court's wrong, then the appeal isn't moot.
Well, the trial court's decision was based on the fact that the court didn't have jurisdiction. It did address Milan as well, but I believe that the original or the basic decision was we don't have jurisdiction to address this. But even if we did, Milan would not fit here.
Justice Khan.
Thank you. Thank you, Chief Justice Robinson. Counsel, my question is this. It seems like your opponent's argument is, well, because she was in contact with the loan servicer and trying to figure out a way to resolve this prior to the law day, meaning up and through the evening of March 12th, that she thought a different route would be taken. But wouldn't that be the case with anyone facing a strict foreclosure or foreclosure by sale? That there could still be attempts to try to resolve the case, whether it's a modification, whether it's satisfaction, but that doesn't mean the law day or the foreclosure by sale gets moved unless there's some action, correct?
Exactly, Your Honor, and that is what happened here. Letters were sent out. She was told that she needed to submit additional documents. She didn't do it. She called. In October 29 to 28 correspondence, the defendant was told that the short payoff was taken off the table. February 20th, 2019, she's told if you have submitted a completed application, which the records show she didn't submit. And then on March 6, 2019, a letter which says your request for workout assistance has expired. Now, all of this going on doesn't negate the fact that her attorney knew about the law day. Her attorney told her about the law day. And there's a 5-year history here, I believe, of the law day being set and then being moved. But there were motions to open, always timely filed there. And her attorney certainly knew about it. There's testimony in the record as to Attorney Hoffman letting her know about it. His office practices was to call the client the week before and get direction as to what should occur. So there are contacts, continuing contacts, but we can't lose the sight of the fact that she was still represented by counsel during this.
Thank you. Please continue, counsel.
So the courts have made exceptions to the rule that to 4915A that they'll only be opened that a judgment will only be opened when the courts will agree to it or the parties will agree to it. But as the defendant agrees in her brief, such exceptions are rare and exceptional. And there were no rare and exceptional circumstances here. The defendant does not claim fraud. She claimed bilateral confusion. And she was represented by counsel throughout this entire process. The defendant was not misled. And in certain cases that were referenced in the brief, this court recognized that the parties cannot confer subject matter jurisdiction upon agreement, such as in Hayes v. Beresford. But in Jaeger, the court allowed the judgment to be opened to correct an error. But there was no error in this case. In Milan, there was, as we noted before, there was a false certification. That did not occur here. And in Ferguson v. Sabo, there was a waiver. The plaintiff had waived his rights or her rights or its rights. And a waiver is an acquiescence or an agreement. So that case falls in line with with the statute, 8.2 of the statute. There were no broken promises here. As we went through the correspondence before, the correspondence, although there was a March 13th date, she already knew that date was not right. In fact, the testimony she gave was when she called the servicer on the law day, she told them that was the law day. So there was no confusion. She knew what it was. I would like to address the amicus brief, if the court will allow. The amicus brief argues that this court should establish a standard for opening judgment directly through a post-vesting motion to open. This case is proof positive that although the bar for opening is high, rare and exceptional circumstances, a borrower who alleges he has no opportunity to make defense or was prevented from doing so by accident or the fraud or improper management of the opposite party and without fault on his own part. And that's from Milan, pages 12 to 13. This court has recognized that vesting can be undone. And in Ferguson v. Sabo, where there was waiver or acquiescence, that is clear. None of these decisions, though, are at odds with 4915. They simply confirm a court's inherent authority to open a judgment where fraud, duress, accident, or mistake has occurred, as stated in Kenworthy v. Kenworthy. The Amicus Brief relies on Cavallo v. Derby Savings Bank to ask that a standard be adopted for a motion to open. The standard there is the same standard set forth in Milan, and the standard that the trial court in this foreclosure action employed when it denied the defendant's motion to open. That is, where the appellant had no opportunity to make a defense or was prevented from doing so. In this instance, the trial court did determine that notwithstanding the provisions of 4915, the court had the power to open the judgment consistent with the holding in Milan. The court then noted that because the facts of this case are quite distinguishable from Milan, it is inappropriate for the court, to invoke its equitable powers to grant relief that is inconsistent with the mandates of 4915A. Contrasting the facts in the instant matter, the Milan, the court noted that, again, as we said before, that she was represented by counsel for 5 years. She appeared, and there were 16 to 18 motions to open judgment. She clearly knew the impact of the law day based on her conversations with her, we assume, with her attorney. And we know that he notified her of that. And as we noted before, the reliance on discussions with the servicer really has no bearing on that. If the parties were confused, the attorneys certainly were not confused. And we know her attorney did call her, the record indicates that the attorney's office would have called her the week before to discuss this. And in fact, had emailed her, I believe, with the date.
Counsel Justice Mullins has a question.
Good morning. I think still, I just want to spin out a scenario for you to see if you could maybe help me understand it. So suppose at the trial court, title passes and there's a motion, and in the motion, the allegation is there was some accident. Pick any one of the equitable sort of avenues. Accident, there was fraud, there was some sort of one of the identified factors that the motion could, if that claim is made out, warrant opening the judgment. So let's say it was accident that was alleged. The court has a hearing, and through the hearing determines there was absolutely no accident. There's no merit to that claim. If the defendant appeals, what would be the basis for the appellate court not to be able to review whether the trial court was right about the merits of its determination on the accident? Even though the trial court found it was meritless, would the appeal be moot in that the appellate court couldn't even address whether the trial court was right about saying there was no accident?
I would think if that scenario played out and the court invoked its equitable powers to find that there was no inequity, the decision there is not based on the fact that the law day has passed and title vested. It's based on the equitable reasons. And this court did not do that. This court said title passed already, the law day passed. But even if I look at Milan is not applicable here.
Because these circumstances didn't rise to the level that they did in Milan.
Exactly. They don't even.
But I guess I'm wondering, what if the trial court was not correct about that? What if the circumstances could be made out on appeal that the trial court was wrong? This really was a valid accident. I'm understanding you to say you can't even raise that on appeal. You can't get review of that claim on appeal.
No, I'm not saying that.
Okay.
If the trial court's decision was based on the equitable argument, and that's what the decision was, and that's not the case here, then it is likely that that may be reviewable. But in this case, the court did look at Milan, but its decision wasn't based on Milan. Its decision was based on the fact that the law date passed and title had vested and it didn't have jurisdiction. And I think the Milan was then just surplusage. It was something that was raised. The judge did address it, but it wasn't the determination, ultimate determination.
I don't know if I have the order right here, but Justice Daria and Justice Ecker have questions.
Okay, I'm not sure either, but I'll go. You make the point in your brief. I just want to make sure I understand this right. The letter is conditional if your application is complete, but I take it your client's position it was only incomplete because of the amount of money that she was going to put in. That her offer wasn't enough. It wasn't a paperwork issue. It wasn't something else that was missing. Am I right about that?
The letter, the letter that originally went out said that she should submit documents, and it did mention the offer amount. She was clear that she did not submit any additional documents. She called, but she didn't submit documents. She didn't meet. She didn't follow the instructions at all. And in any event, her offer didn't come up. I think she offered $500,000. The property was, I think she owed almost over 1.2 million.
So, but your position at the hearing in front of Judge Gennario, I take it, was as simple as there's no misrepresentation here because her application wasn't complete because we needed an extra $25,000 or there wasn't going to be a deal.
Right. We did not accept her short pay application. That was, yeah. And that 25,000 was her words, not ours.
Thank you.
Thank you.
Justice Ecker?
I'm good, Chief. Thank you very much. My question's been answered. Thank you.
I'm just going to go back to the housing clinic's brief again. The housing clinic's premise that it filed its brief to provide additional perspectives regarding the practical implications of the trial court's decision ignores the fact that the trial court did exactly as the clinic proposes should have done. They actually did, the trial court did analyze it. Its argument that both the trial court and appellate court accepted the plaintiff's argument that they lacked jurisdiction over this foreclosure proceeding once the law date passed and title had vested, ignores the fact that there was an evidentiary hearing held in this matter. And everybody was given the opportunity to testify. The housing court brief relied on TULOC, but that is an instance where the clerk's office failed to schedule a hearing on the motion. Appellant had no opportunity to make a defense, again, one of the factors in Milan, or was prevented from doing so by accident. Another case mentioned was the Caruso matter, but that's where the defendant had lost his home in foreclosure after his wife of many years concealed the financial aspects of the home. But there, in that case, again, there was misconduct that time with regard to attorneys that had been court appointed. So again, there were extenuating circumstances, not rising to the level of fraud, but certainly rare and rare circumstances. I have no further comments unless anyone has questions.
Thank you, counsel. So I'm assuming you're going to rely on your brief or any other arguments?
Yes, I am, Your Honor.
Thank you very much. Attorney Brown, I didn't note here how much time you wanted for rebuttal. How much time did you want?
I asked for 7 minutes, Judge.
Thank you very much.
Are you turning it over to me, Chief Justice?
Yes, sir, I am. Sorry for not being clear.
I just wanted to be clear. Justice Ecker, to answer your question about that you asked me about Jager, in that case, the trial court granted the motion to open, the post-vesting motion to open. The appellate court reversed, saying there was no jurisdiction, and then this court reversed the appellate court, saying there was jurisdiction. Justice McDonald, you had asked me a few questions about, well, what about title passing and how do we deal with this? And Pelley said in her argument that she agrees that vesting can be undone. So that would suggest to me that there's no dispute here that something can happen after the law date that puts title back into the pre-law date.
Counsel, but under subsection 2, it's got to be by agreement, right?
Yes, but there's that other statute, which I can't remember off the top of my head, that is cited in my brief, that gives a court that's exercising equitable discretion the power to transfer title. So it would seem to me that combining those two things or taking them in tandem, it can happen. And in fact, well, I guess it didn't really happen in Milan, but the motion at the trial court was to open so that the action could be dismissed. And this court reversed for further proceedings in accord with this decision. As far as I know, the case did continue below. So if the vesting could not have been undone, there would not have been anything to continue below. The other thing we've had some discussion, I believe it was in response to Justice Doria's question about this completed application, and it was only dealing with the $525,000 and $575,000 offers. The argument that's in Pelley's brief is that Rothmel didn't comply because she didn't submit the counteroffers in writing. Rothmel's testimony was, I faxed them 2 counteroffers, which is exactly what the letter, which I believe Attorney Shavoka was referring to, in the February 20th letter. First of all, it doesn't say you have to submit additional information. It says if you have any additional documentation or information you would like us to consider. She had already faxed the 2 counteroffers in. And then it says you may submit this information via our website, or you may fax the documents. She had already faxed them. So the notion that her application for a short payoff was incomplete is not supported by the record. The record confirms that it was complete because her testimony was she faxed the documents.
So that's my question. Is that what this hearing was about? In front of Judge Gennaro, you took that position. She testified. I mean, whether something's complete or not is can be fairly subjective determination. It sounds like your client thought it was, and the bank didn't think so, and you're reliant on kind of communications, which is sort of a dangerous game when you've got a law day passing. So he didn't seem to credit that her application was complete. Judge.
So I have 2 things to say about that. First is I don't think the memorandum of decision addresses whether the short payoff application was complete. Second thing is the bank didn't offer any evidence about the completeness of the short payoff application. And her testimony was, the question that was put to her in cross-examination was, what was the last complete application that you submitted? And she said, that was the short payoff application that I submitted in October.
I mean, it's your burden. The bank doesn't have to say anything, I would imagine. You have to show that you fit within this narrow exception, and her testifying that she thought it was complete, that's a fairly leading question. What was the most complete, what was your complete application? And it's this. I don't find evidence that I don't see any manifestation that he credited that as finding that it was a complete application.
Well, Your Honor, so the question was put to her on cross-examination, so it was put to her by plaintiff's counsel. And there was no evidence countering her assertion that it was complete and that I had faxed the 2 counteroffers just as they told me to do. So I don't think you can, I don't think it's necessarily fair to draw an inference about what well, let me say it this way. Trial court didn't make any finding about whether the application was complete or not.
And we do or we don't know the amount of those counteroffers?
We do. The first one was $525,000, excuse me, and the second one was $575,000. So unless there are any further questions, I would ask the court to reverse both the appellate court decision dismissing the action as moot, or dismissing the appeal as moot, and the trial court's decision that denying the motion to open.
Thank you very much, counsel. I want to thank both counsel for coming in and attending this oral argument virtually. We really do appreciate the fact that you did that. Sorry for any technical difficulties. We will be in adjournment until tomorrow, I believe at 9:30. Thank you very much, fellow justices. I will see you in the conference room.
Thank you.
Thank you.